that is a really important point that you just made, and everyone needs to grasp this because this is one of the arguments that are going to be had in the public, and really legal arguments that are going to have to be resolved over the next couple of weeks. The concept of concurrent authority here, because the statutory language says may, it means that multiple potential entities have concurrent authority here, right? So what this judge did in not effectively, flat out throughout the indictments of both Letitia James and James Comey today, effectively stole the concurrent power that the Attorney General and potentially the President of the United States has in order to staff his Department of Justice the way he wants to staff it.
Well,
That's
it
what
actually starts with 2 Democrat senators that are stealing
Right.
it, frankly. But before we get to the reason why, I want everybody to understand in 28 USC 564, there is one exception to this statute about who can or cannot be appointed to this position. The only one, and it's section C 1 or 2. Section C1 says that you cannot appoint someone that has already been voted down by the Senate. Section 2, the expiration of 120 days after appointment by the Attorney General under this section. Okay, that would have been Siebert if he had been reappointed to an interim attorney. There was an entirely different person that was not just appointed as an interim U.S. attorney. She was submitted to the Senate to be confirmed. Okay, that's an important distinction there. Because, where is this? What the judge decided to do is rest the power of the executive to pick his prosecutors. She said that no, only the district court may appoint a United States attorney to serve until the vacancy is filled. Only. She made it an exclusionary power or an exclusive authority as opposed to a concurrent power or concurrent authority in there.
No, I don't remember seeing that in the statute. I don't remember seeing in the statute that the Attorney General only has 120 days to temporarily install somebody in that office. Did you see that in the statute? And after that 120 days, they lose that authority entirely? Did you see that?
Well, here's the thing, right? And this is the argument that a lot of folks are having because, again, we have seen over the years, over decades, we have seen different branches of government basically try to wrest or cede power from other branches of government. This Supreme Court and this president is not playing that game anymore. Okay, he's not doing it. And so Will Chamberlain had a really great thread on this earlier today, but I pulled just this one. And I want everybody to understand what he's saying here when he says at the end, this opinion will be reversed. And the reason why is because the Supreme Court, over a number of cases in the last few years, we've seen it with all of the regulatory and the bureaucracy, where through their regulations, they're basically or Congress is ceding their authority to these bureaucracies or to these agencies, and they're making all these regulatory decisions. No, that's not what the Supreme Court has been leading to. Over the past year, the Supreme Court has been signaling that the unitary executive is not just a theory, it is a thing. And what that means is that it's the Constitution and interpretations of statutes that purport to confiscate executive authority, which is exactly what that judge just did. She took the authority to appoint the prosecutor that the unitary executive has decided he wants in that position. She was